In today's workplace, things are evolving quickly and complexity is the norm, but clarity is a choice. This Week at Work is where leaders get practical solutions and timely insights for today's toughest workplace challenges.
Hello, everybody. I'm Phil Brandt, President and CEO at AIM Employers Association. Welcome back to another episode of This Week at Work. Today, we're going to dive into a topic that sits right at the intersection of technology, leadership, and risk, something every business leader needs to understand right now. We're talking about artificial intelligence, but not in the usual angle of productivity and innovation. Today, it's about something more fundamental: trust, confidentiality, and unintended consequences. That intersection of AI and attorney-client privilege. Joining me, as always, is Bert Garland, friend and CEO, friend and co-host of Ogletree Deacons. Bert, how are you doing today?
Phil, I'm doing great. It's great to be here.
Yeah, it's a good day, Bert. This is a great topic. I'm glad we're talking about this. We had a conversation, or you had a conversation with, I don't know, over 100 of our members the other day during your legal briefing, and we barely touched on this topic, but you brought a lot of awareness to it, and I think it's a great topic for our podcast. We can dive a little bit deeper into it. I know you didn't get the time to do that in the legal briefing.
Right.
But before we do that, I guess I just want to find out, is there anything else going on? You know, we like to do lawyer on the clock. This whole segment's going to be lawyer on the clock. But anything else going on that you want to bring to our attention before we get on to the main topic?
Of course there is, Phil. I'm not going to do a deep dive on either of these. I'm going to talk about two developments, and one of these flows really out of what we talked about at the legal briefing about, 10 days ago. Right after the legal briefing on April 23, the Department of Labor's Wage and Hour Division issued a notice of proposed rulemaking to establish a clear, more uniform standard for joint employer status under the Fair Labor Standards Act, the Family and Medical Leave Act, and the Migrant and Seasonal Agricultural Worker Protection Act. The proposal emphasizes a four-factor test focused on actual control. You'll recall during the legal update, I focused on that quite a bit: actual control as opposed to theoretical or potential control, with what the administration or the Department of Labor is calling a quote-unquote totality of the circumstances analysis, but with a heavy weight on that control factor. So this is very similar to a standard that was implemented by Trump in 2020, moving away from broader prior approaches and then the broader approach of the Biden administration. So just be aware that if you are using independent contractors, if you are using staffing agencies, this applies particularly to your business, your operations, and I urge you to read that notice of proposed rulemaking from the Department of Labor. And of course, Phil and I will be here to bring you updates on that.
So what kind of timeline are we looking at for something like this before it either settles in or gets put away?
Yeah, so the proposed rulemaking usually is open for a period of time. Comments are due around mid-June of 2026, so about a month and a half. And then the Department of Labor will review the comments to the proposed rule, make adjustments if necessary. But I would say sometime toward probably the late second quarter, early third quarter, and certainly by the fourth quarter of this year, we're likely to see this implemented.
There you go. So hang tight.
Yep.
What a wonderful topic. We've been talking about this topic, it seems like most of my career, and maybe we'll do it right through the end of my career. It just keeps seesawing. Yeah.
It really does.
It does. All right. Anything else happening out there in the wonderful world of legal developments?
Yeah, I'm going to report on this one, Phil. On April 15th, just a couple of weeks ago, in what was sort of a surprise to me, the Federal Trade Commission ordered a major pest control company in the United States to stop enforcing non-compete agreements against more than 18,000 of its employees, and
Oh,
also
wow.
sent warning letters to 13 other firms in the industry. And the reason why this was a little bit of a surprise to me is because the FTC really, under the Biden administration, had overreached and had really tried to eliminate non-competes. The Fifth Circuit or a district court in uh, uh, Texas had invalidated the rule. It had been appealed, and then the Trump administration dropped the appeal, sort of signaling that the Trump administration's FTC was going to move away from restricting or reining in non-compete agreements. And so this is a big step by the Trump FTC. And what I think it really illustrates is that it's really a shift to an industry by industry or a case by case enforcement approach rather than a broad nationwide ban. So, and I have said for years that this is an area that Republicans and Democrats do seem to have some common ground on. Republicans, from a free trade perspective, they don't love non-compete. And then, of course, Democrats from a position of we want to make it easier for workers to get hired
Hmm.
overall.
Yeah.
And so there is some common ground there. And I just think this one is really interesting because it shows that the Federal Trade Commission is definitely going to continue to scrutinize non-competes as potentially anti-competitive, especially in sectors where you have lower wage or frontline workers. So I think the guidance that I take away from this is that if you use non-competes, employers definitely need to make sure that they're narrowly tailored, especially for the non-senior executives to avoid similar action.
Yeah, I'm guessing by the number of this pest company, the 16, 18,000, whatever it was, that it's not it's maybe the individuals going around and treating homes and businesses with pest control, and
Exactly.
I think about that and I'm like, there's so many jobs out there like that are
Yep.
that I easily say no. If they want to go work from one pest company to another in a capacity of application of pesticides, we should be able to
Yep.
do that. I mean, think about lawn care companies are in that same type of
Yep.
position. Heck, for that matter, you could even say like production workers that maybe they're a machinist, right? And they
Mhm.
operate CNC machines. And then you say, no, you can't go operate another CNC machine at another business. It just that seems reasonable to me.
Yeah, I would tend to agree with you that it seems reasonable to look at the nature of the position rather than doing a nationwide ban on non-competes across the board. I think it makes
Right.
sense to look at the position, and don't forget there's other tools out there such as confidentiality, trade secrets agreements, and non-solicitation agreements that employers can use to protect their legitimate interests without restraining employees' ability to go work for a competitor.
Yeah, and I know for me, I like to lean on that non-solicitation. Like,
Mhm.
we do that a lot at AIM, and we work with either our employees or other partnering organizations, and we're really working in a non-solicitation environment. Like,
Right,
we serve our members, and we don't want someone that we're introducing our members to go and try and poach members. And I think
that's
that
right,
that's a big piece of it, particularly when you get away from the top executive level.
right. That's
Yeah.
right. Yeah,
Yeah.
that's it. And your stock and your customers or your members in your case, that is a legitimate protectable interest under the law.
Yeah. Great. Anything else, Bert?
I think that's enough for today, Phil. I'm ready to get into our main topic today.
All right. So attorney-client privilege. I guess there was a federal judge that made a ruling. What happened in this case? And let's get this thing kicked off.
Yeah, so this was a case, it had to do with criminal law. And what happened is that the person who was the target of an investigation by the federal government went out onto some of the free AI tools that are available and made a number of searches related to the specific issue that he was being investigated
Okay,
about.
so when we're saying we're talking about tools like Chat GPT, Claude, Gemini, Grok, these types of LLMs that are available for free or for fee,
Yep,
that we're using more and more to help bring efficiency and proficiency to our jobs.
that's right.
Okay.
And this person had gone out and made a number of searches related to the activity that they were engaged in at the company, and asking questions about legality, illegality, how to remedy any illegal behavior. Really quite far-ranging questions that this individual asked of the AI models. And what happened was is after the indictment was handed down, and the federal government came in and or maybe it was actually pre-indictment. It was during the investigatory stages. The federal government, the investigators, the FBI, et cetera, came in and seized the individual's computers. And when they seized the computers and they started searching those computers, they found all of these prompts that the person had made to the AI tools and the responses that came back. And the individual who had then been by then been indicted tried to get the court to rule that that evidence was all inadmissible because the person was, quote unquote, seeking legal advice,
Hmm.
and that this was private. And the federal judge said, no, it was not private. You weren't seeking legal advice. You were asking these AI models to give you advice, but AI is not legal advice. You were not doing it at the direction of an attorney at the time. You had not even engaged an attorney. Not that that would have made the difference anyway, but it could be a
Yeah.
factor. And the judge said that this evidence is all admissible.
Wow.
Yes.
That's yeah, that's so what happens? Let me see if I can break that down a little bit. You have a business leader, let's just call him an HR professional, has got some challenges with an employee or a group of employees, whatever that might be the case. They think they're being smart and doing the right thing by using AI to help them think around corners, and they're asking questions, gathering information. They believe they're doing that in the confidentiality of their room or their office on their PC. And then what actually happens is that they might actually be creating evidence that could work against them.
Yeah, that's exactly right, Phil. The defendant in that case used AI independently to draft legal strategies and shared sensitive details in those prompts and those materials that were later seized. The court said that was fair game. It was not protected by attorney-client privilege.
Yeah, yeah. So, all right. So let me jump here. So we've been pushing on this. You and I talking about AI and some of the real
Mhm.
positives that it can bring to an individual and or an organization. But in this format, in the way that it's being utilized, and an open type LLM, you think you're being proactive, using tools, thinking ahead, all those things. And now we're saying, whoa, hold on, pull back. We now have a case law, right,
Yeah.
that says, is this really about AI or is it about discipline? Where are we at in that? Is that an AI issue or a discipline issue or both?
Well, I think you're really talking when you say discipline, I think you mean like restraint. And the court did not say AI is bad. What the court said is that the individual in that case used it without legal direction, shared information with a third party. Because again, when you put information out into those platforms, you are sharing information with a third party that then stores your data and learns from your data. And the individual, the defendant, lost confidentiality in that process. And so the person was not disciplined in their exercise of their use of AI, or did not show proper restraint.
Okay. All right. Um, Yeah, I don't, that's interesting. So it's kind of a leadership issue more than a technology issue. Because here's the way I'm hearing that. You kind of bypass the system and the system doesn't necessarily protect you. So if we dig a little deeper, what I want to challenge is how leaders are thinking about this. So here's a question. If confidentiality is the cornerstone of privilege, are leaders understanding how easily that gets broken in a digital world?
Yeah, I don't think they are fully understanding that, and in that respect, they're underestimating that. And this
Yeah.
case makes that explicit. The AI platform's terms allowed data retention and use, which destroyed any expectation of confidentiality, and certainly attorney-client privilege was never established.
Yeah, so I'm a quick thought in that for me, Bert, is as a practitioner for many years and still even as a CEO has to deal with these challenges from time to time. I take notes and I write
Mhm.
notes, I make notes, I put them in files. I might even do that electronically. I might do it by paper. And now we have this new technology, and I'm like, oh, I can take notes with this technology. I can ask the technology for insights and help me think around corners. And just like those notes that I created may be discoverable and may not be protected because they were not asked or directed under the course of an attorney, so can everything I do in AI.
Well, that's right. I think that in that respect, using AI is not that different than you preparing internal notes, investigatory notes. If that's being done independently of an attorney, and even if it is being done at the direction of the attorney, there's a line of case law out there that says you can't use it in investigation both as a sword and a shield. If even if the attorney directs you to do the investigation, your investigatory notes are ultimately going to be discoverable. And you, as the employer, want those to be discoverable because it shows that we complied with our legal obligations to investigate claims of harassment, discrimination, whistleblowing, etc. And
Right.
so, again, from that perspective, your notes are very similar to the AI prompts. They're going to be
Okay.
discoverable, and you want those in many circumstances to be discoverable.
Yeah. So let me just position this another way. Are we created, by encouraging and using AI, and it's always, feels very helpful. I know when I use it, I'm usually impressed with how effective it can be. Are we creating a false sense of security with what we would call smart tools like AI that feel private but aren't?
Absolutely. I mean, many people assume that the tools function like internal systems, but legally they're third parties. And a way we might be able to illustrate that, Phil, is let's say an HR person is investigating a complaint of discrimination in the workplace. And the HR person feeds in some of the investigatory notes and then asks for next steps. And the AI
Okay.
tool provides some advice for next steps, and then the HR person doesn't follow those. That's creating a false sense of security that this was private because if a plaintiff's attorney gets a hold of that information down the road, uh, they're likely to ask, well, you went out and sought this advice, and this advice that you got back from these AI tools told you to do X, Y, and Z as part of your investigation, and you didn't do it. And
Yeah.
don't you, and so you get in, you may be opening up a whole can of worms there. So
Yeah.
again, I think that the use of these tools, there's definitely the issue of creating a false sense of security.
Yeah. Yeah. And I think about just like cultures of organizations and, what does that say on how organizations are or are not educating their people on AI? We do. I mean, I counted, I think we've done 14 or it was 14 or 16 education sessions in the first quarter of Q1 alone on AI
Hmm.
and
Hmm.
covering topics in addition to like just how to be proficient with it, but topics like this as well, of using it in the most responsible way. So educating their people on AI risk is going to be critically important.
Yeah, I mean, the ruling definitely suggests companies should proactively guide their employees on AI use, especially
Mhm.
in legal or sensitive context in which you may want to preserve confidentiality.
Yeah, absolutely. All right, here's a big one for you. If an employee uses AI independently, could they unknowingly expose the entire organization?
Well, I think so. That's one of the practical implications. Information shared with AI can be discoverable.
Yeah,
I mean, it's
yeah,
pretty simple.
yeah. So if we flip it around, is there a right way we can do this? Is there a more safe or secure way in legal or sensitive environments or topics?
Yeah, I think, first of all, under attorney direction, and then I think is one level. And then the other one, and we talked about this at the legal update a couple weeks ago, is using secure or enterprise grade tools with confidentiality protections. I mentioned that we at Ogletree have AI tools that are available to us, but what's different is that those AI tools are housed in-house for us, and the data remains on our servers, and the language models can't learn what they learn from our data. They can't use externally, and so we take steps to protect the attorney, to protect and preserve the attorney-client privilege and the attorney work product doctrine.
Yeah, that's a big difference that you mentioned there. Kind of these open platforms like Chat GPT, the free version, or I pay $20 a month and I get additional capacity and usage rights with my purchase.
Right,
Um, that's very different than our company has built an AI system that's specific to our company for specific task.
right.
Um, Now, talk to me about like Gemini or something like that that's built in where a lot of companies, well, we don't use ChatGPT, we use Gemini.
Okay. Well, so I think that
Still an LLM, it's a third
yeah,
party, it's not in-house. I guess that's the direction I would go to, I would think.
Yeah, I think that's right. It's still a third party, and if it's not in-house and it wasn't at the direction of an attorney, I think you're running the risk that it's going to be discoverable down the road.
Yeah. In preparation for this, I'd put into Chat GPT the same question that I put into Grok, and I got pretty similar answers um, from both, and they emphasize the responsibility and confidentiality and the risk slightly different. Um, one takeaway I got is like if you wouldn't CC a stranger on an email to a lawyer then don't put it into AI. I mean, I thought
Right.
that was a pretty good rule.
It used to be that I used to joke around about emails that don't put anything in an email that you wouldn't feel comfortable putting in a postcard.
Yeah.
And I think since I used to joke about that, email has gotten more secure than that. But you never quite know when that's going to come out in discovery or what's going to be discoverable. And you should always be sort of thinking ahead of how could this be used against me down the road.
Yeah,
That's what I would
absolutely.
encourage people to do.
Yeah.
Use the AI tools. They're great. They're actually amazing and astonishing. But you need to be careful.
I can we just spend a short minute, Bert? Let's talk about like if I'm using it to help me build a policy, is that something I should be concerned with on confidentiality? I'm just drafting some policy language. Maybe I'm going to run that by the AIM hotline when I'm done, or maybe or send it over to your team and have it reviewed. Does that create a problem in general?
It can, from the perspective of, number one, what the AI tool is returning to you. It may be very good, but it also might not be good. And if you go ahead and implement that without a legal review or a consultant's review, you may be implementing something that's wrong or improper.
Oh
Okay.
yeah. No,
Uh,
I'm not saying write the policy, use it on AI, and don't have AIM or Ogletree review it.
right.
I'm saying
I know you're not. Yeah.
send it to us.
Yep.
I'm asking the prompts that I put in it. Is there risk in the prompts? Um, I guess I can think of some examples where they could be. If I said, "Hey, here's my policy," I put it in. I'm
Mhm.
dealing with these problems with these employees, and Bert's giving me a headache every Saturday and Sunday because I FMLA on these things. Like that would be the risk.
Correct. That's
Yeah.
right. And also to the extent you ask, you dump in an employee handbook or something, and you ask the AI tool, "What's wrong with my employee handbook? Is there anything that needs improving?" And then you get this big list back or a revised version of the handbook, and then you don't implement any of it, or you don't have it vetted by AIM, or you don't have it vetted by Ogletree, and it just sits. And yet it's pointed out all of these things that where your policy manual might be illegal, unlawful, or deficient.
Yeah. No, and you talk on previous episodes on This Week at Work where it's like we act on information that either we are aware of. So it's what, we often take action. We're responsible to take action responsibly with what we know. And sometimes there's what we don't know, and all we can do is really act on what we know.
Mhm.
So in this case, where I see that playing out is someone says, well, you should have known, right? Because you were told. So now you did know. Whether you believed it, you didn't think it was right, you should have known.
Yeah. Well, and that's almost going back, Phil, to the legal standard for harassment and discrimination in the workplace. The legal standard there, literally from the courts, is that the employer knew or should have known of the harassment.
Yeah.
And it's kind of that same analysis there that if we knew that something was wrong or we should have known that something was wrong, we have an obligation to address it. And in other words, we can't be negligent. A should have known standard is kind of like a negligence standard. And if we
Yeah.
ask the AI tool to go through and point out what might be wrong, and then we ignore it and just leave it after that, that could be, in a sense, negligent.
Yeah. I'm going to just take it another step further. Because I've heard of these examples, and we even talk about it in some of our training, and we talk
Mhm.
about it in our roundtables, because there's this element of AI that creates other problems for some of employers. So, for an example, if I'm out, let's say I'm working in a manufacturing facility, a warehouse, a construction site, somewhere where there's traditionally more safety hazards than an office, right?
Right.
And I grabbed my phone and I'm like, well, that doesn't quite look right over there. And I got my hard hat on and I snap a picture of it and I put it into my LLM and I ask it, is this a safety hazard I should be concerned with? And it comes back and says, yes. In
Right.
fact, that's missing machine guarding. And according to CFR 29, blah, 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 machine guarding says this, and this is an immediate danger to life and limb, and you should report it immediately to OSHA, right? So
Or
now
you should immediately cease operation of that machine until the guard is placed back on the machine.
all these things, and it may or may not be right. We don't
Right.
know. But that can create a problem. And not only does it say, stop operations, it says, here, you can report that to OSHA. Here's the local number based upon your zip code. Here's the address. Here's a written document to send them, right? And
Hmm.
it and the email address and bang, it just makes it so easy to do. And it may or may not be right. Or it could be that an employee brings it to your attention and you ignore it or you didn't give it the immediate attention it needs. And now you get into a willful situation.
Well, yeah, that's a great point. I mean, if in your particular example, if somebody's using a machine in a factory and they had removed the guards, we take that picture, send it into one of the AI tools, and it comes back and says, yes, this is an immediate uh, present concern, safety concern, you should cease operation of the machine. And that person is you don't stop the operating of the machine, and the person ends up slicing their fingers off. Well,
Yeah.
you were on notice that this you were potentially on notice that this was an urgent issue. You were aware of the potential of it to be urgent ahead of time because you thought enough to take the picture and ask the question of the AI tool. It shows that you had
Mm,
some knowledge of this, and then the AI tool comes back and tells you stop using the machinery, and you didn't. So yeah,
yeah.
and if that comes out in discovery, that's really damaging evidence.
Yeah, no, you can think about it. And I bring that up because it's not just what we put in, it's how employees might use this as well.
Right.
And yeah, it just brings up a lot of really a little bit of Pandora's box in some of the cases.
I was going to call it the proverbial can of worms, Phil.
Can of worms, yeah, absolutely. All right, so let's simplify this a little bit. Confidentiality is absolutely important. Every person listening to this understands that. And when we use third parties, we have the potential of exposure and that breaking our privilege rights and so forth. You can't fix it after the fact. At that point, it's out there, it's in the public domain, just like if we sent an email to everyone. And intent isn't really going to protect us as much as the process will. Am I missing anything there?
No, I think you're exactly right. Maybe I'd add that the court definitely rejected the idea that AI could act as a legal intermediary, and it
Mm,
emphasized that privilege must exist at the moment of communication, not later. So again, an
yeah,
example of that would be if an attorney is directing somebody in HR to do something, uh, then the privilege exists. Now you're likely to again waive the privilege at some point, or the conversation that the individual had with the attorney that remains privileged. But then the HR person's investigation, that's not privileged at that point when they start going out and talking to third parties. So the privilege has to exist at that moment of communication, not later.
yeah, yeah, absolutely. All right, well, I guess in bringing this together, this is where I bring it back to leadership. And I know at AIM, we spend a lot of time helping organizations build strong people systems. And this is just how I break it down. Technology will always outpace our policy. We see it all the time.
For sure.
It's for me, it's almost like the new radar detector is always better than the radar system the police are using. And
Phil, I've
unless,
I've moved I've moved on to Waze. If you
yeah,
don't know about Waze, that's much better.
yeah,
Go
but
ahead. Sorry.
but, and I agree with you. I'm on ways too. And the police are in there saying that they're not there anymore.
Right.
Yeah.
I've heard that.
All right. So unless we step in as leaders, there can be some risk. So if we don't step in and define how AI is going to be used, really simply put, our employees will. We have to define it and recognize our employees might still use it in their own ways. And this is something we've been talking with employers about, is we have to define the framework and then we have to manage that very well. And we're never encouraging employers not to use it. We're just talking about how to use it and what is the definition of fair use for your business, depending on the risk profile of your organization. If you don't educate your team on the risk, I mean, it becomes decentralized and you're probably going to have more of it. And if you don't align legal and operational strategy, we're just going to create more exposure.
I think that's right. I think that's what this case illustrates, Phil.
Yeah, yeah. I mean, AI is powerful, but it's not neutral, really, in that sense. Yeah, it amplifies. I mean, to me, whatever system you already have, if your systems are disciplined, intentional, and aligned, you kind of are ahead of the game. You're going to probably be just fine. If they're not, you're just creating more risk, and potentially at scale when you think about how much everyone might be putting in that system.
Yeah. I couldn't agree with you more.
Yeah, absolutely. I mean, it's a great topic. I never saw this one coming, to be honest. When I heard you talking about it last week, I was like, "Oh, that's a good topic." We're going to make sure to have that included in all of our training going forward. And Bert, thanks for keeping us up to date there.
Happy to do so, Phil. Always glad to be a part of it.
All right. Well, Bert, we're going to get back on the air here on May 26th. I think we're going to discuss smart glasses at work. It's kind of in this same realm. And if you don't know what smart glasses are, look them up and join us on May 26th. Now, let's all go out there and let's be good to somebody. Take care.